First, thank you for tuning in. I'm Eli Sluter with Sluter Law Firm. I'm a virtual in-house counsel. I help business owners from entrepreneurs with startups all the way through to established business owners who are ready to start thinking about succession planning. I help them with a wide range of legal matters, many of which will be topics of videos such as this one. Here's what we're talking about today. But before we get into that, I do want to remind you that while I'm licensed in Arizona, New Jersey, and Pennsylvania, this information is not state specific. It's just general information, not legal advice, and you watching this video does not make you my client. Okay? Let's talk business law.
I would like to touch on why it's so important that every LLC have a written operating agreement. First and foremost, much like in estate planning, if you don't have a written estate plan, you fall back on the state's intestate laws, which are confusing and not well understood and what most people would not want to rely upon. The same is true with your LLC. You need a written operating agreement to avoid falling back on the state laws insofar as if you don't have an operating agreement, how assets are distributed, who has what voting rights, and how profits are allocated and assets distributed upon dissolution. Additionally, you want to make sure that you have a written operating agreement to help establish the LLC as an independent, separate entity from its owners. This is very important because if you just commingle your funds, the LLC funds with your funds, and you don't treat the LLC as a separate entity, as almost like a separate person from yourself, you can risk losing that limited liability protection under the alter ego theory, it's called. So it's important to have a written operating agreement for those reasons. Also, even if you're a single member LLC, the operating agreement can be simple, but at the very least it should have your succession planning, your exit strategy. What happens if you get hit by a bus? Somebody can come in and take over the management and make sure your company doesn't die in the vine, whether you're still alive or if you pass away, to preserve that value for your heirs, to be able to liquidate the LLC. If you pass away unexpectedly and you don't have this structure in place, your LLC can come to a screeching halt and lose a lot of value because it's no longer operating, right? So you want to have somebody that can come in and take over that management. You may want to set forth a purpose. Either you can be very broad, or if you have other managers or multi-member LLC that's member managed, you may want to be very specific and say, hey, this is a pest control company. We provide pest control services. That would help prevent somebody from going out and saying, oh, I was authorized to use the LLC to go buy a rental property and become a landlord, right? Because that would definitely be outside the scope of the LLC's purpose. You may want to have restrictions on the managers. Managers can't spend more than $5,000 or $10,000 or whatever the dollar amount is without the member approval. Managers can't do certain things, take out loans or buy major assets. You can set forth in the operating agreement which decisions require member approval. You can also put procedures in there for the removal of a manager if they're not doing a good job. When you talk about the managers or the members voting, you have to decide which issues have to be decided by managers versus members, and then is it just a majority, a supermajority? If you use a supermajority, you have to define that. Is it 2/3, 3/4, or unanimous, right? What's it require? You may set forth fiduciary duties. You may say the managers have a fiduciary duty to the LLC. That includes they can't compete with the LLC. They can't, it's an exclusive engagement. They're not out there doing other, trying to start other businesses at the same time that they're managing the LLC. So that's where you can kind of define the scope of their commitment to the LLC, if you will. This is a huge one, dispute resolution. What happens, if there's a deadlock? I get this a lot. They get two people that come and say, we're best friends since kindergarten. We're going to start a company. We're 50-50 down the line, right? It's either unanimous or nothing. Well, you're going to run into those issues where it's deadlocked. One person wants to do something and the other wants to do something else, or they disagree on something. So it's important that there's some sort of resolution, whether you name one person as a general manager and they're the deciding factor, or they flip a coin, or they go to a trusted advisor and let them decide as an arbitrator, whatever it is. It's important to have a dispute resolution process in place to avoid deadlocks and gridlock. Also, you want to make sure that your operating agreement details what your tax treatment is. We talked about electing to be taxed different ways. Whether you're a partnership or an S corp, your operating agreement is going to be different. Accounting procedures with partnerships, there's all sorts of different allocations, special allocation rules that you don't have with a corporation or an S corp. So it's important to have an operating agreement that reflects that and that has provisions for if the entity is audited, the LLC is audited. We talked about the new partnership audit rules and how they can require the partnership be on the hook for unpaid taxes. So you want your operating agreement to deal with that and to make clear that if that happens, those old partners, even if it's not a partner anymore, they're still on the hook. So those type of provisions are important. Also, you want to have rules regarding additional capital contributions, for instance. If the company needs money, can the managers require the members to put funds in? Is it only a majority of the members vote and then all the members have to contribute? Those types of decisions. That's usually those are the decisions that get sticky, right? When it comes to having to put more money in, and also with the allocation and distribution of profits. We talked about unequal allocations versus equal. And also you can have your operating agreement can require that the LLC make a tax distribution, right? Just because you allocate profits, if you don't distribute them, if it's taxed as a single member or a partnership, those owners will still owe taxes on the allocated profits, even if the profits aren't distributed. And so it's important, you may want to have that tax distribution provision in there that says at the very least, the LLC is going to kick out enough cash to pay the taxes on the profits allocated to me but not distributed. And finally, you want to make sure that there's clear structure for managing the capital accounts and keeping track of the funds that have come in and when money goes back out, how that's accounted for to the owners. You would also want to have restrictions on transfers, procedures for adding a member, and how to deal with when a member withdraws. And finally, there's a whole other class that we have on this, buy-sell provisions, but your operating agreement would have buy-sell provisions for if somebody dies, if it's an active member in the LLC, what if they become disabled for a long time and they're not able to deal with the company anymore? At what point are they required to sell the company, sell their interest in the company, or if a member files bankruptcy, for instance? What if some third party comes along and offers to buy out one of the partners or one of the members, right? The other members and the company, you want to have them have a right of first refusal. And then there's tag along, drag along rights. Different type of buy-sell provisions. Like I said, there is a buy-sell succession planning class that I recommend that you go listen to that explains these things in much greater detail.
So there you go. Thanks again for tuning in. I hope you enjoyed that short video, or if you didn't enjoy it, you at least found it informative. My name is Eli Sluder. I'm a Sluder law firm. I'm a virtual in-house counsel mostly to business owners and real estate investors. I help with a wide range of business and contract matters, anything from non-disclosure agreements, independent contractor agreements, buying and selling businesses, things like that. Estate planning, I can help anybody with estate planning, but it's especially important for business owners to have an estate plan in place early. Succession planning, that includes buy-sell provisions or standalone buy-sell agreements. Asset protection is something that applies to everything that I do. Real estate, anything real estate and related, whether it's residential, commercial, whether you're buying, selling, or leasing, and if you're leasing, whether you're a landlord or a tenant, I can help. Finally, trademarks. I want to make sure that the brand that you are putting all your blood, sweat, and tears into building is something that you can protect and that isn't infringing on somebody else's rights. Like with everything else that I preach, it is very important to remember that an ounce of prevention really is worth a ton of cure. Why do I preach that so much? Because I've seen the ton of cure too many times. So please give me a call sooner rather than later. I'm happy to help you. All right, thanks again.